Zuma, who was then president, took out the 7.8 million rand loan from VBS in 2016 to pay for non-security upgrades at his Nkandla homestead, prior to the bank being placed under curatorship. This followed a ruling by the Constitutional Court in March 2016 that Zuma was in breach of the Constitution for flouting then Public Protector Thuli Madonsela's directive to pay back public money used for upgrades at his private rural home, which included a swimming pool, amphitheatre and cattle kraal. Zuma started defaulting on the loan payments 2 years later. Since bringing the court application for summary judgment in 2019, the curator says Zuma made sporadic attempts to pay towards the loan, which led to several postponements of the application hearings. With no real defence raised by Zuma's legal representatives this week, his legal team consented to judgment being granted.
Generally, in a matter like this, if there's no matters, or if you don't raise adequate defence, or if you're unable to raise an adequate defence, then the person or the legal representatives will end up conceding or consenting to the order.
And having consented to the order means that the liquidators can attach Zuma's movable assets.
When a judgment is granted, it's an order of the court, that makes the full amount due and payable immediately. And then what that does, it allows the bank in this case to recover the monies by attaching assets, which it would sell and realize in order to pay down the debt. And, that process is also a legal one where the sheriff would be engaged in order to go out and do an inventory of the assets and, of course, attach the assets so that this could be sold and realized for cash.
Rooplal couldn't say when the process of debt collection was to start. Renee Heine, SABC News, Durban.